can see him right now. Step away from that door and drop the hardware.
Officer, you are trespassing. This is a private residence. Lower your voice.
I got a call about a break-in, and you don't look like you belong in this zip code, lady. How'd you get past the doorman? Who'd you steal that key from?
A mistake you cannot undo.
Retired Chief Justice Shauna Jones had spent 30 years inside courtrooms where one word from her could end a career, overturn a verdict, or set a constitutional precedent that would echo for a century. She had written opinions that were taught in law schools from Stanford to Harvard. She had presided over cases that reshaped California's entire criminal justice system. She had survived confirmation hearings, death threats, and political firestorms that would have broken anyone without her particular combination of brilliance and iron nerve. Before we go any further, what city or state are you watching from? Drop it in the comments below. We love knowing where this community reaches. And if you believe that owning a $5 million penthouse while Black should never require a woman to prove her innocence at her own front door, hit like and subscribe. This story is about to show you exactly why the system fails, and exactly what happens when the system picks the wrong woman to fail. On the morning of March 13th, she was standing in the marble hallway of her own $5 million Los Angeles penthouse, the home she had owned outright for 11 years, dressed in a tailored slate-gray blazer, ivory silk scarf, and gold earrings, holding a cup of coffee and her morning brief, when Officer Dale Miller stepped off the elevator with his hand already moving toward his holster. Officer Dale Miller had been on the LAPD for 9 years. He had 23 complaints filed against him. 17 of them involved stops or detentions of Black residents in high-income zip codes. Not one of those complaints had resulted in a formal disciplinary hearing. His supervisors had documented the pattern. His supervisors had done nothing about it. Miller had learned something from that silence. He had learned that in buildings like this one, when someone who looked like Shauna Jones opened a door, the assumption wasn't she lives here. The assumption was she doesn't belong here. When Shauna opened her penthouse door and calmly said, "Officer, I own this unit. I've owned it for over a decade." Miller looked her up and down, the silk scarf, the professional posture, the absolute certainty in her voice, and said, "Ma'am, I'm going to need you to step into the hallway and keep your hands where I can see them." Shauna stepped forward. "I have my deed and my ID in my handbag right here, if you'll allow me." "Do not reach into that bag." "Officer, I am the legal owner of this property. I am a retired Chief Justice of the California Supreme Court. I am going to show you my identification." Miller's response was 3 words, "Hands on the wall." Shauna Jones looked at him for a long, measured moment. The same look she had given defense attorneys who tried to intimidate her witnesses, prosecutors who overreached, and officers who came before her bench with sloppy, rights-violating arrests. Then she said, very quietly, "You are making a catastrophic mistake." Miller told her to stop talking. What Officer Dale Miller did not know, what he was about to discover in the most irreversible and professionally devastating way possible, was that every second of this encounter was being captured in 4K resolution by the building's security system, by his own body camera, and by the hallway camera of the neighbor across the hall who had cracked their door open the moment they heard raised voices. He didn't know that the anonymous burglary tip that had sent him to this floor had originated from a number already flagged in the department's own database for filing false reports. He didn't know that the woman he was pressing against a mahogany door had personally authored the legal brief that established the evidentiary standards police departments across California were currently required to follow. He didn't know that inside the handbag he had refused to let her open was a phone currently recording audio. And he absolutely did not know that in approximately 4 hours, the precinct commander who had personally attended 3 of Shauna Jones's landmark rulings was going to walk past a holding cell, stop dead in the corridor, and whisper, loud enough for 2 officers and a desk sergeant to hear. "What in God's name have you done?" The city of Los Angeles had been dealing with this specific problem for years, and the people who lived in its luxury towers knew it just as well as the people in its lowest-income neighborhoods. They had just been largely invisible to the departments assigned to protect them. The LAPD's Wilshire Division had been the subject of 2 internal reviews and 1 external audit in the previous 5 years, all of them centered on the same documented pattern: a statistically improbable concentration of welfare check and suspicious person calls in high-end residential buildings that resulted overwhelmingly in the detention of Black and Latino residents who, in every documented case, turned out to be exactly who they said they were. The complaints had been filed, the data had been compiled, and in nearly every case, the outcomes had been the same: a notation in the officer's file, a brief supervisory conversation, and a return to business as usual. Shauna Jones had watched this pattern from a distance for most of her career, had, in fact, issued rulings that were specifically designed to make this kind of stop legally indefensible. She had written the opinion that established clear probable cause standards for residential detentions. She had written the dissent, later upheld on appeal, that dismantled the anonymous tip defense that departments had used for decades to justify pretextual stops. She had done her work from the bench. She had changed the law. And then she had retired to her penthouse on the 40th floor and assumed that the law she had written would be enough. Shauna Jones was 64 years old, the daughter of a schoolteacher and a postal worker from Compton, and she had spent 30 years building one of the most formidable legal records in California history. She had served on the Superior Court, the Court of Appeal, and had been appointed to the California Supreme Court, where she served as Chief Justice for 11 years before retiring 18 months ago. She was the author of more than 200 majority opinions. She had been awarded the American Bar Association's highest honor. Her portrait hung in the Hall of Justice on West Temple Street. She had bought the penthouse with money she had earned. She had paid property taxes on it every year. She had a doorman who knew her by name, a building manager who had her personal cell number, and neighbors who waved at her in the elevator. She had never once considered, in 11 years of living there, that she would need to prove to a police officer that she was allowed to stand in her own hallway. She had not considered it, until the morning that Officer Dale Miller stepped off the elevator on the 40th floor and decided, before she had spoken a single word, that she didn't look like someone who belonged there. This is the story of what happened next, and what it cost everyone who looked the other way until it was too late. The call came in at 11:47 a.m., a burglary in progress at the Meridian Tower on Wilshire, 40th floor, penthouse unit. Anonymous tip. No description of a suspect beyond a Black woman who doesn't appear to belong there. The dispatcher flagged it as low priority. Miller flagged it differently. He took the call himself. He rode the elevator alone, one hand loose at his side, already running the scenario in his head the way he always did, the way 9 years on the job had taught him to, or so he told himself. High-rise building, luxury unit, anonymous report. He had a picture assembled before the elevator doors opened, built from assumption stacked on assumption, the way a structurally unsound building is assembled, quickly, confidently, and with no attention paid to what happens when the weight shifts. The 40th floor hallway was silent and immaculate. Marble floors, crown molding. A window at the far end framing a postcard view of the Los Angeles skyline, all glass and haze and distance. The kind of hallway that belonged in an architectural magazine, and Miller walked through it without seeing any of it, because he was already focused on the door at the end. He knocked twice, official, authoritative. The door opened. Shauna Jones stood in the frame, tailored blazer, ivory silk scarf, reading glasses pushed up on her forehead, a legal brief folded under her left arm and a coffee cup in her right hand. She looked at him the way a woman looks at something mildly inconvenient, not afraid, not startled, simply present and composed and waiting for him to explain himself. Miller's right hand dropped to his holster. Not because she had moved, not because she had reached for anything or raised her voice or given him a single actionable reason, but because the picture he had assembled in the elevator didn't match the door code he'd been given, and rather than question the picture, he tightened his grip on it. Shauna had faced worse than this. She had faced it in courtrooms where men with law degrees and expensive suits tried to rattle her with procedural tricks and barely concealed condescension. She had faced it in confirmation hearings where senators who had never read one of her opinions questioned whether she had the temperament for the bench. She had learned over 30 years that the most powerful thing she could do in a room that wanted her to be afraid was to refuse, absolutely and without performance, to be afraid. So she kept her voice level, measured, the same voice she used when an attorney was grandstanding, and she needed the courtroom to understand, without drama, that it was time to stop. Officer, I own this unit. I have owned it for 11 years. My identification and my deed are in my handbag. I am going to reach for them now. She moved her right hand toward the bag on the entryway table. Slowly, deliberately, the way you move when you are trying to make something undeniable. Miller said, "Stop reaching. I am showing you my ID." "You are reaching, ma'am. Stop. I am a retired Chief Justice of the California Supreme Court, and I am showing you proof that I live here." What happened next took less than 4 seconds. Miller crossed the threshold, grabbed her left arm, and turned her into the wall, the silk scarf catching against the molding, the legal brief hitting the marble floor, pages spreading across it like something discarded. He told her to stop resisting. She had not been resisting. He told her the claim of ownership was a sophisticated lie, a phrase so specific, so rehearsed-sounding, that it suggested this was not the first time he had needed a reason to dismiss what someone was telling him. The coffee cup had shattered on the floor. The building's security camera captured every frame of it. Miller had not yet looked up at the camera. He would not look up for another 6 minutes. The handcuffs were standard issue. Cold, functional, indifferent to the wrists they closed around. Miller cinched them with the practiced efficiency of someone who had done this hundreds of times, and then he walked Shauna Jones toward the elevator the way you walk someone you have already decided is guilty, hand on her arm, slightly ahead of her, controlling the pace. Shauna let him. Not because she had no choice, though legally, in that moment, she had very few. She let him because 30 years on the bench had taught her something that most people never learn about power, that the most dangerous thing you can do to someone who is abusing it is to give them nothing to point to. No struggle, no raised voice, no tears. She walked through that hallway with her spine straight and her chin level, and she began to speak. Quietly, calmly, directly into the body camera clipped to Miller's chest. "This is a warrantless entry into a private residence," she said. "That is a Fourth Amendment violation. The resident, myself, offered proof of ownership and was physically prevented from producing it. That is a violation of clearly established constitutional rights under Bivens. The use of physical force in the absence of resistance or threat constitutes excessive force under the 14th Amendment." She paused as the elevator doors opened onto the lobby. "I want the timestamp on this footage noted. 11:54 a.m. The lobby was not empty. 3 of her neighbors were at the concierge desk when the elevator opened. A woman she had shared the residence committee with for 6 years. A retired federal judge she had known since 1998. A young couple she recognized from the building's holiday gathering. They all turned at the sound of the doors. The silence that followed was the particular silence of people watching something that should not be happening, something they could not immediately process because it was too wrong to absorb quickly. Shauna looked at each of them in turn. She did not look ashamed. She looked like a woman who was building a case. Because she was. The processing room at the Wilshire division smelled like burnt coffee and old paperwork, and Miller was in a good mood. He dropped Shauna's handbag onto the evidence intake counter with the casual confidence of a man who had done this before and expected the same outcome he always got: a notation, a release, a quiet resolution that would disappear into the department's filing system like everything else had. His partner, Officer Reyes, was leaning against the far wall scrolling through his phone, and Miller said something to him in a low voice, and Reyes laughed, and Miller said it louder. "Chief Justice, you believe that? They all claim to be someone." He shook his head with the weary amusement of a man who considered himself an expert in other people's deceptions. Last month it was a city councilman. Month before that, a federal prosecutor. He pushed the handbag toward the intake officer without opening it. "Book it with the rest." The intake officer started to say something. Miller was already walking away. What was inside that handbag, what Miller had decided was not worth 30 seconds of his time, was a California State Bar card. A retired judicial credentials card embossed with the seal of the California Supreme Court. A building fob registered to Penthouse 4001. A phone with 6 minutes and 40 seconds of active audio recording. Business cards from the offices of 3 of the most prominent civil rights attorneys in the state. Because Shauna Jones had spent her career knowing exactly which calls to make when a situation required them. And at the very bottom, tucked into a leather document sleeve she carried everywhere out of habit developed over 3 decades, was a folded copy of the deed to Penthouse 4001, notarized, dated, and registered with the Los Angeles County Recorder's Office. Miller didn't look inside the bag. He never looked inside the bag. That single decision, that 4-second dismissal of a woman's entire documented life, would later consume 47 pages of the civil complaint filed against him. Shauna sat in the holding area and waited. She had spent 30 years understanding exactly how long it takes for the truth to surface when someone has been determined to bury it. She was patient. She had time. And she was already composing in her head the opening paragraph of the most consequential deposition of Officer Dale Miller's career. Commander Gerald Watkins was having an ordinary Thursday. He had reviewed 3 disciplinary reports that morning, sat through a budget meeting that ran 40 minutes over, and was walking back to his office with a sandwich he hadn't had time to eat yet when he passed the holding area at 1:22 p.m. and glanced through the reinforced glass the way he always did. The automatic, half-conscious scan of a man who had run this precinct for 11 years and knew its rhythms the way a ship captain knows the sounds of his own vessel. He stopped walking. The woman sitting in the 3rd chair from the left was in a tailored blazer with an ivory silk scarf, her posture so composed and deliberate that she looked less like someone who had been arrested and more like someone who was waiting for a meeting to begin. She was looking at the wall directly across from her with an expression Watkins recognized immediately, because he had seen it before, in a courtroom, on a day 7 years ago when he had sat in the gallery and watched her dismantle a defense attorney's closing argument with 4 consecutive questions, so precise, they had made the room go completely still. He had attended that session voluntarily. He had wanted to see her work in person because her reputation had preceded her across every level of California law enforcement for 2 decades. Her portrait hung in the Hall of Justice on West Temple Street, had hung there for 11 years, and he had walked past it enough times that her face had become part of the architecture of his professional life. His sandwich hit the floor. He was through the door in 4 seconds. In 8 seconds, he was standing in front of her saying her name. Not ma'am. Not the suspect. Her actual name, with the particular weight of a man who understood completely and immediately the magnitude of what someone in his department had just done. Shauna looked up at him with the same measured calm she had maintained for the past 90 minutes and said, simply, "Commander, I was wondering how long that would take." The power in that room did not shift gradually. It inverted completely, and everyone present felt it happen. The internal investigation was opened before the end of that business day. Commander Watkins personally signed the order, which was unusual. Typically, these things moved through channels, accumulated procedural delays, got handed down and passed sideways, and eventually arrived on someone's desk with enough distance from the original incident that the urgency had been carefully bureaucratically drained out of them. Watkins bypassed all of that. He signed the order at 2:47 p.m. and hand-delivered it to Internal Affairs himself. What the investigators found, once they started pulling Miller's documented stop history, was not a surprise to everyone in that building. That was the part that would later prove most damaging in court, not the numbers themselves, but the evidence that the numbers had been seen before and filed away like something that didn't require a response. Over 9 years, Miller had conducted 340 documented stops in high-income residential zip codes. 94% of the individuals detained were Black or Latino. Of those 340 stops, not one, not a single one, had resulted in a conviction. 23 had resulted in formal complaints. 17 of those complaints had been reviewed, summarized, and closed without disciplinary action. The remaining 6 had never been formally reviewed at all. The investigators pulled his body camera archive going back 18 months. They found a pattern so consistent it had the character of policy. The same language used to justify stops that had no legal foundation, the same dismissal of credentials and identification, the same escalation when residents pushed back with the specific, informed confidence of people who knew their rights. The footage didn't show a rogue officer having bad days. It showed a methodology. Practiced, repeated, and protected by the silence of every supervisor who had read the complaints and decided the paperwork was sufficient response. Miller's attorney would later argue his client had simply been doing his job. The investigators' report, all 94 pages of it, would spend considerable time explaining, in precise and unsparing language, exactly why that argument was the most damning thing his attorney could have said. Shauna Jones had given testimony in courtrooms for 30 years, but she had always given it from the elevated position of the bench, looking down, presiding, controlling the temperature of the room with the quiet authority of someone who decided when things began and when they ended. Sitting in the witness chair was a different geometry entirely. She had thought about that before she agreed to testify. She had agreed anyway, because there were things she needed to say that a settlement check alone could not say for her. Her attorney had advised her to keep her answers short. Shauna had listened to this advice carefully, and then, with the particular respectful firmness she had deployed on attorneys for 3 decades, explained that she would be doing something else. What she did, over 4 hours of direct and cross-examination, was dismantle Officer Miller's decision-making with the same methodology she had used to write opinions, starting from first principles, building the argument brick by brick, and arriving at conclusions so structurally sound that opposing counsel's objections bounced off them without leaving a mark. She explained unconscious bias not as a moral accusation, but as a documented cognitive mechanism, citing peer-reviewed research by name and date. She walked the jury through the legal framework of Terry v. Ohio, through the 4th and 14th Amendments, through the specific California statutes that governed residential detentions. And she did it in language so clear and accessible that the jurors were leaning forward in their seats before the first hour was finished. She described what Miller had done not as hatred, she was precise about this, but as the operational consequence of bias that had been permitted, documented, and institutionally protected until it calcified into standard practice. She explained that the most dangerous form of injustice is not the kind that announces itself, but the kind that has been made comfortable enough to stop questioning itself. When opposing counsel suggested that Miller had simply been doing his job, Shauna looked at him the way she had looked at 1,000 attorneys who had said something they would immediately wish they hadn't, and said, "Then the job needs to be dismantled and rebuilt from the foundation." And that is precisely what this verdict will begin. The jury deliberated for 4 hours and 11 minutes. In civil rights cases of this magnitude, that was not a long time. It was, however, long enough for Miller's attorney to tell a reporter in the hallway that he was cautiously optimistic, that juries were unpredictable, that his client had simply been doing his job in good faith, and he believed 12 reasonable people would recognize that. He said the words, "good faith," twice in 4 sentences. He would not say them again after 3:18 p.m., when the jury filed back into the courtroom and the forewoman stood up with the kind of composed deliberateness that told everyone in the room, before a single word was read aloud, which direction this was going. $20 million. Unanimous. The written verdict was more devastating than the number. The jury had not simply found against Miller. They had systematically rejected every plank of his defense with a specificity that read less like a jury finding and more like a judicial opinion, which several legal commentators noted was almost certainly a consequence of 4 hours spent absorbing the testimony of a woman who had written several hundred of them. The Miller defense, the argument that he had been acting within the reasonable scope of his duties, was rejected in language the court later cited in full. The jury found that Miller had been presented with multiple opportunities to verify Shauna's identity and ownership, had actively refused each one, and that this refusal was not negligence but intentional disregard. A distinction that mattered enormously, both legally and financially, because it meant the city's standard liability protections did not apply. The court further noted that the institutional failure surrounding Miller, the 23 complaints, the 17 closed without action, the supervisors who had read the pattern and done nothing, made the city itself jointly liable in a way that could not be characterized as anything other than deliberate indifference. Miller's attorney had no statement for the cameras. Miller himself left through a side door. Neither of them looked up as they walked past the portrait of Shauna Jones, which someone had quietly moved from the Hall of Justice and placed, temporarily, in the courthouse lobby for the duration of the trial. 3 weeks after the verdict, Shauna Jones rode the elevator to the 40th floor, walked the length of the marble hallway, and unlocked her front door with the fob that had been in her handbag the entire time. She stood in the entryway for a moment. The morning light was coming through the floor-to-ceiling windows the way it always did, flat and gold, and indifferent to everything that had happened since the last time she had stood here without handcuffs on her wrists. The skyline was the same. The mahogany door across the hall was the same. The building carried no visible record of what had occurred inside it, which was, she had decided, precisely the problem with systems that absorb injustice without changing shape. She set her briefcase down and got to work. The Shauna Jones Justice Initiative was incorporated within 60 days of the verdict. It was funded entirely by the settlement, not the punitive portion, which she donated to a scholarship fund for underprivileged law students, but the compensatory damages, every dollar of which she directed into a national training program she had been designing, in outline form, since the morning she sat in a holding cell and waited for the truth to find its own way to the surface. The program was not a sensitivity workshop. She was deliberate about that distinction in every interview she gave. It was a rigorous, historically grounded curriculum, mandatory, credentialed, and built into the certification requirements of every participating department. That taught officers the documented history of housing discrimination in America, the legal framework that governed residential detentions, and the specific, measurable consequences of allowing bias to function as probable cause. Within 2 years, it had been adopted by departments in 23 states. Shauna never described what happened to her on March 13th as a tragedy. She described it, when asked, as a data set, one that had finally been collected by the right person, in the right building, with the cameras already running. She had spent 30 years writing the law. It had taken one morning in handcuffs to make certain the law would finally be taught. If you like this video, make sure to hit that like button, subscribe, and turn on the notification bell so you don't miss the next story. Share this video with someone who would appreciate it. And let's keep building this community together. And before you go, drop a comment below. I'd love to hear your thoughts on what stood out to you the most. Until next time, stay safe, stay curious, and I'll see you in the next.